This is Michael Popok with a Legal AF hot take. Well, there's hot off the presses news. Donald Trump has filed a motion, finally, a full brief to disqualify Judge Merchan in the criminal case that is starting on the 15th of April because he happens to have a daughter, and that a daughter is an adult, and she has her own political opinions and First Amendment right, and she works for a political organization or entity that represents Democratic causes out of Chicago. And if you're scratching your head saying, well, what does that have to do with a judge's bias? Give me some proof or evidence, Popok, that Judge Merchan is biased against Donald Trump, and maybe we're talking about something. Nope. The motion that's been filed is all about Lauren Merchan. It's detailed. It's granular. It goes to a level of prolix detail I have rarely seen about a judge's direct relative. I know now everything about Lauren Merchan. I know about her resume, her LinkedIn, what her titles have been at Authentic Campaigns out of Chicago, how much money Authentic Campaign raises, who is their client list from their website. I mean, it is startling the amount of information I have that has nothing to do with the bias of the judge that I now know about Lauren Merchan based on the filing. There's a fundamental problem with the motion. None of this indicates that the Judge Merchan has an actual interest, a financial stake in the outcome of the case so that he's got a bias. None of his rulings indicate bias. There's no facts that indicate bias that have been provided to the judge. And the appearance of impropriety is just Donald Trump being annoyed that somebody who happens to be a Democrat, the judge, has a daughter who works for Democratic causes. Well, that's not enough. I know they throw a one-liner in their motion that says, well, many New Yorkers, this is without citation to any evidence, by the way. This is just Todd Blanche on behalf of Donald Trump just spouting off the top of his head, which is basically the entire brief. I mean, it's just basically 3D printed out of Donald Trump's mind onto a piece of paper. And there they say, many New Yorkers would be upset if the judge's daughter was a MAGA person. What does this have to do with anything? I mean, other than they want to spend 37 pages telling for fundraising purposes, telling everything that people want to know about Lauren Merchan without connecting the dots ever. Let me explain something to our listening audience, if it's not already apparent. Judges are allowed to be married. Judges are allowed to be in intimate relationships. Judges are allowed to have grandparents and parents and children and aunts and uncles and husbands and wives and all of that. They're all allowed to do that. And those relatives or offspring are allowed to be thinking human beings that hold jobs. Particularly, they are allowed, for instance, to work in Democratic causes, to have First Amendment rights, to freedom of expression. Family members don't forfeit their right to participate in public life, in political life, in religious life, in charitable life, in civic life, because they happen to be married to a judge. And by contrast, if a judge could be disqualified just because somebody like the defendant in a criminal case didn't like what their fill-in-the-blank relative did for a living or what they said on their social media account, we wouldn't have any judges at all. They'd all be recused. And that's the problem with Donald Trump's motion. All it is a prolix recitation to the granular detail of everything I didn't need to know and I don't need to know about Lauren Merchan, the daughter of the judge. What's wholly missing in the entirety of the 37 pages is any shred of evidence that indicates that Judge Merchan, the one that matters here, wearing the black robe, that Judge Merchan has a bias against Donald Trump, has said inappropriate things about Donald Trump outside the courtroom, or it can't be his ruling because rulings can't be the basis of bias, or that there's an appearance of impropriety or an appearance that justice is not being done in that courtroom. Not anywhere. I've looked high and low in all 37 or 38 pages. It doesn't exist. The entirety of the spilt ink is all in wasted space, is all about, the judge has a daughter and she happens to be employed. I'm going to read to you, of course, from certain aspects of the motion. And to try to get around the problem that they filed this exact same motion a year ago, and there's no new evidence. Nothing that they cited Let me make it clear. Nothing that Donald Trump's lawyer cited in the filing today wasn't available to them a year ago. Pulling things off the Authentic Campaign's website where Lauren Mershon works, that was all available to you a year ago. All the information about the campaign or how many people the types of Democratic clients they have, or that Lauren Mershon worked at one time for the Kamala Harris campaign or for the Biden campaign. Now, look, this would be a different hot take if it was suddenly revealed that Judge Mershon himself worked for Kamala Harris, Joe Biden, the Democratic National Committee, or worked as a consultant or as an outside general counsel for Authentic Brands. I guess. I mean, it doesn't matter to MAGA or to Donald Trump when people like Judge Kaczmarek in Texas, the federal judge there that rules all the time against women's right to choose, he was general counsel for a right to life organization out of Texas. That doesn't seem to bother anybody, that his political views were on full display. But nothing about this hot take is going to be about Judge Mershon because nothing in the motion filed by Donald Trump is about Judge Mershon. And everything that they're raising now, they should have or could have raised a year ago when it was denied the first time they moved to dismiss Judge Mershon. What they say with a quick back of their hand in a dispatch is, Judge, yes, Judge, you rejected this a year ago, but you can't reject it now. There's new evidence. There's no new evidence. The only new evidence is Donald Trump then was expected to be the Republican nominee, and now he is. When the judge spoke, for instance, in the last year's order denying this very same motion, almost identical, he said it was remote and speculative, not about whether Donald Trump was going to be the nominee, but it was remote and speculative as to whether the relationship between Lauren and her work, the work with the other campaigns, Lauren and her father to Donald Trump presiding over his case, whether that chain that I just described showed a bias or an appearance of impropriety, and that it was so remote and speculative and conjectural that it certainly could not, and nothing has changed in the current filing. Pulling out of the website pages for Authentic Brands their client list doesn't change the lack of merit or grounds for this motion. Detailing exactly how many titles Lauren Mershon has held at Authentic Campaigns doesn't matter. The heart of the matter for the appellate court, for the judge when he considers the motion to recuse, because this motion has to be decided at first instance by the very judge himself. And Judge Mershon is not going to see anything new that's going to change his mind from a year ago because there is no new evidence. They say, aha, the judge has given an interview to AP News about this case. And he said some things about this case. It shows bias. You want to know what the quotes are that even Donald Trump, had to put into the motion itself? That it's an intense case where he's going to have to apply the facts and the law. Whoa, that's the bias? The judge is going to do his job and apply the facts to the law? By the way, he's not even applying the facts to the law. The jury is applying the facts to the law. This is a jury trial. Donald Trump didn't get indicted by Judge Mershon. Donald Trump didn't get indicted by the Manhattan DA. Donald Trump got indicted by a grand jury in New York. Donald Trump will not be tried by Judge Mershon. He'll be tried by 12 citizens from Manhattan, residents of Manhattan, in a state jury trial. The judge is making pretrial decisions the way all trial judges are done. And let me just warn Todd Blanche here. I know he's got an address in New York, but it almost looks like he barely or rarely practices here. As the judge once reminded Todd Blanche, this very same lawyer, just 2 weeks ago in his courtroom, he said, Mr. Blanche, what did you do before you became a private lawyer? He said, I worked in the Department of Justice. I was an assistant U.S. attorney in New York. This is when Todd Blanche had a good reputation. He said, how many years were you an assistant U.S. attorney? Todd Blanche said, 13. The judge says, well, you know better. As a 13-year assistant U.S. attorney, you know better about the federal system. He doesn't apparently know anything about the state system or the proper grounds to recuse a judge. And so they say to the judge, yes, you denied this very motion a year ago. And yes, you got an ethics opinion from the Judicial Ethics Board, an advisory opinion telling you did not have to recuse based on the relationship between you and your daughter and Authentic and the Schiff campaign out in California and this case. That was so attenuated and remote that there's no way you need to recuse yourself, nor is there an appearance of impropriety. And based on that and getting that advisory opinion, the judge refused to recuse. He's going to do the same thing here. They said, but we don't know what you told the advisory committee. We need to know. No, you don't. No, you don't. He's a judge. He has his own ethics canons that he needs to abide by. And he's done it. And he's told you that as an officer of the court. Just as you, Todd Blanche, are an officer of the court, at least for now, you're an officer of the court as well. And so you have an obligation, as the judge has warned you before, to bring motions in good faith and based on merit, or you can be sanctioned. And now I think the judge, having now looked at and told them, you want to file a motion, but I'll review it to determine if it's in good faith, in bad faith, and whether it should be granted or denied. The judge is going to deny this motion. I'm just waiting. We'll do another hot take on what the Manhattan DA is going to respond. All right, legal AFers, I need to tell you not just about any jeans, but the perfect jean. Today's sponsor, The Perfect Jean, finally solved all of your denim difficulties. They make great-looking, perfect-fitting jeans that are as comfortable as sweatpants. I tried them. And I promise they are now my favorite pair of jeans I own. The secret? A special denim fabric that's super soft and has the perfect amount of stretch so you can squat, do yoga, or just sit around all day in them without ever wanting to take them off. They make 6 fits from skinny to thick and have a waist from 26 to 50 and lengths from 26 to 38. Big boys, short kings, tall dudes, and all the rest, they got you. For a limited time, our listeners get 15% off their first order, plus free shipping at theperfectjean.nyc, or Google The Perfect Jean and use code LEGALAF15 for 15% off. My pair of The Perfect Jeans are incredibly comfortable. They're stretchy in all the right places, and I could not recommend The Perfect Jeans enough to anyone who's looking for an amazing pair of jeans. It's finally time to stop crushing your groin in uncomfortable jeans by going to theperfectjean.nyc. Our listeners get 15% off your first order, plus free shipping, free returns, and free exchanges when you use code LEGALAF15 at checkout. That's 15% off for new customers at theperfectjean.nyc with promo code LEGALAF15. After you purchase, they'll ask you where you heard about them. Please support our show and tell them that we sent you. Forget your khakis and get the perfect jean. Let me just, so you don't think I'm just sort of blowing smoke here. Let me read to you from certain aspects of this motion that was just filed. This is a total of, 35 pages. And I've read it and I've compared it to the motion that was filed a year ago. And there's really nothing new here, except they got very good at learning how to cut and paste and put in photos and screen grabs into their brief. All right, good for you. This is what they say at the very beginning, which is when you're a lawyer advocating, your best arguments are always at the beginning, and it's in the introduction or the preliminary statement. Listen to this preliminary statement, and you tell me if this is a compelling argument or not. President Trump, which the judge always referred to as the defendant. President Trump respectfully submits this memorandum. Okay. Your Honor's daughter, Lauren Mershon, here we go, has a direct financial interest in these proceedings by virtue of her ownership stake and leadership role at Authentic Campaigns. Based on public disbursements data, that means the amount of money that their clients used for fundraising and raised and then paid a commission to Authentic. Authentic, which surveys exclusively Democratic clients, is the number 21 ranked vendor in the country for the 2024 election. Again, having nothing to do with how Judge Mershon gets paid every day as a state court, Supreme Court judge. In 2019, Ms. Mershon made public statements during a podcast regarding a conversation with Your Honor that reflects bias against President Trump from both speakers in that exchange. Let me clarify that. Lauren Mershon on a podcast said she had a conversation with her father about Twitter and that he exclaimed that he found it distasteful that certain politicians, and he didn't name Trump, used Twitter for their rhetoric. What does that have to do with the Stormy Daniels hush money business record fraud case? There's no Twitter element to the case. And the fact that the judge expressed an opinion about his view about other politicians that may or may not include Donald Trump and their use of social media, what does that have to do with the bias in the case? And Laura Mershon has a full First Amendment right, the same First Amendment that Donald Trump likes to talk about incessantly, to state her opinion in the podcast. That's the extent. That's it. But I don't want you to think I'm editing out anything. That is the extent of the conversation on the podcast. Then they go on to say that at least 6 of Authentic's clients, having nothing to do with the judge, and used fundraising solicitations that reference this case around the time of the indictment, the arraignment, or following the judge's denial of the recusal motion. And they made money from that. Oh, okay. It's public knowledge and a matter of public record how many times Donald Trump has been indicted or arraigned or filed motions that were baseless and were denied. The fact that, sure, I am sure that there's been fundraising around that, just as Donald Trump, talk about pot calling the kettle black, uses the same events to fundraise for himself. What does that have to do with Judge Mershon, an appearance of impropriety or a bias? They never explain that. They go on to say that Donald Trump's, this is on page 2, Donald Trump's success in the primaries, which followed the court's rulings on the previous recusal motion, has cemented his status as a political target of Authentic, Ms. Mershon, and their clients. While that appears to be consistent with the company's views, the most important consideration for the purposes of this motion is that Authentic benefits reputationally and makes more money by targeting President Trump. Again, to be clear, if they were able to insert the phrase, Your Honor benefits personally and financially from the campaign fundraising of Authentic because you get some sort of pension because you used to work there, that would be a different motion. But that's not this motion. And that's why this motion will fail. Then they go on to double down on the deleted X account or Twitter account for Lauren Mershon. It's already been established by the press and the media that she deleted that account a long time ago. Somebody picked up the account and fraudulently and fakely impersonated her and posted photos of Donald Trump. That she has an opinion that she expressed about Donald Trump before that, about when he left office and writing, see ya or whatever she wrote on it. That's her First Amendment right. Again, relatives of a judge don't forfeit their right to be part of our society because their relative wears a black robe. That is not the law. They go on to say, and this is one of my favorite lines, this is on page 3, the court's interest in these proceedings by virtue of the close relationship with an immediate relative and Ms. Merchant's ongoing receipt of commercial and reputational benefits based on the manner in which Your Honor has conducted these proceedings requires recusal based on an actual conflict and an unacceptable appearance of impropriety. No case is cited for that proposition. This is easily illustrated by the fact that it would be completely unacceptable to most New Yorkers if the judge presiding over these proceedings had an adult child who worked at WinRed or MAGA Inc. What? I don't understand that at all. Again, same principle. Judges aren't disqualified because of statements made or work positions taken by one of their adult children. That's not the law in New York, nor in any other state, Todd Blanche, and you know it. Then they go on to describe in excruciating and ridiculous detail, which is masquerading as support for their, or legal support for their position, right? Hyper detail masquerading as support. They go over, here's the Authentic's client list. Here's a screen grab. They love screen grabs. Here's the President Biden and Vice President Biden, President Biden and Vice President Harris screen grab for something that Lauren Mershon worked on. God love her, she has a job. I think that should be the position. They raised money for the Senate Majority PAC and the House Majority PAC, and they've been fundraising through the indictment. Okay, again, it's not a crime or a grounds for disqualification that Lauren Mershon has a job. And then they get to the law. Are they finally going to get to the law? On page 17, which they quickly misstate. And they say that they have a right, and they cite to Judiciary Law, Section 14, that a judge shall not sit as such in or take any part in the decision of an action in which he is interested. ... To be disqualified, a judge must have an interest. The judge must have an interest in the subject matter of the suit, not Lauren Mershon. The interest need not be large, but it must be real. I agree with that recitation of the law. The problem is in the application of that law to their facts, they are dead on arrival. And they go through the court rules, and then they go through this ridiculous discussion that starts on page 19 that, again, is all about Lauren Mershon and her job. And the cases they cite are completely an opposite. They talk about they have to take on the fact that the judge back in April 2023 received an advisory opinion from the Advisory Committee on Judicial Ethics, but they say that all of that happened after the judge made a series of decisions and after Lauren Mershon deleted her X account, and therefore this all must be suspicious as to why the judge went for a ethics opinion. They say the timing and the appearance of impropriety that it creates cannot be ignored. Sure, it can be ignored because there is no appearance of impropriety. And then when they go on to talk about the interview, here, this is one of my favorite parts, the interview. This is on page 22. In addition to the court's public statements regarding Ms. Merchant's X account, in other words, they came out and said that wasn't her X account. The Associated Press published an article on March 17th of 2024, which disclosed that Your Honor had participated in an interview with the media last week. Your Honor reportedly indicated that the court wouldn't talk about the case, which is exactly true. But then they say that the judge did so anyway, but listen to how they say the judge talked about the case. Your Honor reportedly stated, and now I'm like, I'm breathless. Like, what did he say? That one, quote, getting ready for the historic trial is intense. Okay. Number two, the court is striving to make sure that I've done everything I could to be prepared and to make sure that we dispense justice. Okay. And there's no agenda here. We want to follow the law. We want justice to be done. That's all we want. Okay. Let me just cut to the chase. A judge saying he's going to be a judge, he's going to apply the facts to the law, and that he's going to do justice, and that it's an intense case, does not rise to the level of extrajudicial statements demonstrating a bias by the judge. It's a recitation by the judge of his job description, at best. And so they cite to the rule against public comments about a case, but they don't acknowledge the case law that says what those kind of public statements can and cannot be. And then he talks about the gag order, right? And they say, and then you gagged us inappropriately. And your daughter works for the number 21 ranked vendor in the country in this election cycle. And we just smush it all together. That's a legal term. And we'll argue that you're biased and that you need to go. All right. I'm going to warn Todd Blanche here as a New York lawyer. You're skating on thin ice, my man. This is borderline bad faith filing and meritless. And if I'm the judge, I would both deny the motion, sanction the lawyers, and refer them to the Appellate Division First Department for a bar evaluation and a bar grievance, which judges can do. Because enough is enough. Enough is enough to go after the soft underbelly of the court system, to go after civilians who are family members and bash them incessantly in order to try to destabilize the court, the justice system, public confidence in the justice system, to try to scare off potential jurors, to undermine witnesses, goes beyond the pale. And now the judge has to act. Now, I give the judge a lot of credit. He didn't have to ask for full briefing. He didn't have to allow Donald Trump to hang himself with another 35 pages, but he did. And now we'll watch the Manhattan DA file their brief, and then the judge is going to rule. And sit back, because that's going to be an amazing hot take that either Ben or me or Karen Friedman Knifler are going to get to do. We do it right here on the MeidasTouch Network and on Legal AF, and we bring it to you every week, just like this, on a podcast we call Legal AF. Join us on Wednesdays and Saturdays at 8 p.m. Eastern Time. You'll find out why we call it that. And then we do hot takes like this one about every hour right here on the MeidasTouch Network. So until my next hot take, until my next Legal AF, this is Michael Popak reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.